The courtroom in Caldwell County had not seen a crowd like this in 11 years, not since the Fenwick murder trial. Every bench was full. Farmers in feed store caps sat shoulder to shoulder with women clutching church bulletins repurposed as fans, all of them waiting to watch 79-year-old Walter Iverson do something nobody thought a strokes-load arthritic old dairyman could do: destroy a lawsuit with a cardboard box. Denny Coats sat at the plaintiff's table in his one good shirt, sweating through the collar, because he was 6 weeks away from being handed half of the Iverson family farm, 140 acres, a limestone farmhouse, and a dairy barn his grandfather had helped raise beams for in 1958. 28 years of labor, Denny's lawyer had argued, created something the law called a resulting trust. 28 years of tending Walter's cattle, mending Walter's fences, planting Walter's corn, deserved to be recognized as ownership, not just tenancy. And for 5 months, it had been working. Then Walter's granddaughter wheeled in 4 bankers' boxes and set them on the defense table with a thud that made the court reporter jump. "Your Honor," Walter's attorney said, "we'd like to enter into evidence 412 individually dated handshake agreement receipts beginning March of 1973. Denny Coats' lawyer stood halfway up. "Objection, Your Honor, this is overruled," the judge said, not even looking up. "Sit down, counselor. I want to see this too." What came out of those boxes over the next 40 minutes would not just end a lawsuit. It would end a friendship, expose a secret Denny Coats had buried for a decade, and prove that in Caldwell County, the man who wrote everything down always outlasted the man who assumed a handshake was enough. This is that story. Caldwell County sat in the kind of rolling Kentucky farmland where the fences had been standing longer than most of the people who mended them, and where a man's word, for most of the 20th century, was worth more than a signature. Walter Iverson had built his whole life on that belief. In March of 1973, when a 22-year-old field hand named Denny Coats knocked on his kitchen door looking for steady work, Walter didn't offer him a contract. He offered him coffee, then a job, then 6 months later a deal. "You work this land like it's yours," Walter told him, "and I'll treat you fair. You'll never starve on my dime, Denny. I take care of my people." It was the kind of promise that meant everything and legally nothing. And for 28 years, that gap didn't matter because Walter Iverson was, by every account in 3 counties, a man who kept his word to the letter. He paid Denny a share of the milk check every month. He let Denny and his young wife Loretta live rent-free in the tenant house on the property. When Denny's roof caved in during the '89 ice storm, Walter paid for the repair out of his own pocket and never once brought it up again. What almost nobody knew, because Walter Iverson did not consider it worth mentioning to anyone, including his own children, was that every single one of those handshake arrangements got written down. Walter had learned bookkeeping in the Army, and he never lost the habit. Every deal he ever struck on a handshake, he went home and typed a 1-page memo about that same night on an old Smith Corona typewriter. Who the deal was with, what was promised, what was exchanged, and the date. He called them his receipts. Though no money changed hands over paper, they were memory, made permanent. He kept them in a fireproof lockbox in the hall closet, then later in a filing cabinet in the room his late wife Doris used to call the sewing room. Nobody asked why. Walter never explained. He simply said when his son once caught him typing one up at 11 at night, "A handshake's only as good as the 2 men who remember it the same way. One day one of us won't remember it the same way." I intend for that not to be me. For 28 years, those words sat quietly in a drawer gathering dust, doing nothing. Until the spring Denny Coats decided a handshake could mean something different than what Walter had always understood it to mean. Walter Iverson's stroke came on a Tuesday in October, mild as strokes go, but enough to put him in a walker and slur the left side of his speech for 3 months. His son Gary, who had left Caldwell County decades earlier for an insurance career in Louisville, came home more often after that, and it was Gary who first noticed something had shifted in Denny Coats. Denny had always called Walter boss with something close to affection. Now he called him Walter flatly, like a business acquaintance. Denny had always brought the milk check ledger up to the house for Walter to review together, the 2 of them at the kitchen table the way they'd done it for decades. Now Denny mailed the numbers in an envelope, no note, no visit. Gary asked his father about it. Walter waved it off. "Denny's tired, 28 years wears a man down, give him room." What Walter didn't know, because Denny made sure he didn't know, was that Denny had spent that autumn in a Bowling Green law office, talking to an attorney named Russell Aldrich about something Aldrich called a claim of equitable ownership through long-term improvement and reliance. Denny had described in detail everything he'd put into that farm across 28 years. Fences he'd rebuilt with his own lumber, a new well he'd dug in 96 cattle he'd helped select and breed, seasons where he'd worked 80-hour weeks without complaint, because Walter always said, "You're taking care of this place like it's your own, and one day it will be." Aldrich's eyes had lit up at that phrase, "like it's your own, one day it will be." Did he say that in front of witnesses? Aldrich asked. Denny thought about it. "My wife heard him say it plenty of times, so did his own kids probably growing up." Aldrich leaned back. "Mr. Coats in the state of Kentucky, decades of unpaid or underpaid labor performed in reasonable reliance on a promise of future ownership, especially where the landowner benefited from that labor and made repeated statements suggesting a future transfer. That's not nothing. That's a doctrine called Promissory Estoppel, and paired with what's called a resulting trust theory, I think we can make a real run at this. Not the whole farm, but half is not unreasonable, given what you put in versus what a wage-earning tenant would have. It was Aldrich more than Denny who turned an old man's affectionate encouragement into a legal weapon, but it was Denny who signed the papers. By January, Walter Iverson, 79 years old, 3 months out of a stroke, still relearning how to grip a coffee cup with his left hand, was served with a civil summons at his own kitchen table by a sheriff's deputy who couldn't quite look him in the eye. The complaint, when Gary read it aloud to his father in the front room, ran 14 pages, and it made Walter's world tilt sideways in a way the stroke never had. It claimed that Denny Coats had worked the Iverson farm for 28 years at wages substantially below fair market value, in express and repeated reliance on Walter Iverson's promises that the farm would in some form become his. It claimed Denny had made capital improvements, fencing a well, drainage work, barn repairs, using his own money and labor improvements that permanently increased the farm's value, and that basic fairness required the court to recognize a constructive or resulting trust over half the real property in Denny's favor. It asked the court, in the alternative, for damages equal to the difference between what Denny had been paid and fair market wages across 28 years, which Aldrich's own expert had calculated at just under $650,000. Walter sat very still through the whole reading. When Gary finished, the old man said only one thing. He signed his name to that. Not he's lying, not how could he, just the plain fact of it, delivered like a man noting the weather had changed. Gary, watching his father's face, understood something in that moment that would matter enormously in the months to come. Walter Iverson did not intend to fight this suit with outrage. He intended to fight it with paper. Dad, Gary said carefully, do you remember all those things? Saying that stuff to him, about the farm being his one day. Walter was quiet for a long moment. I remember plenty of things I said to plenty of people over 50 years, Gary. Encouragements cheap to give and expensive to take back, apparently. But I remember something else too. He pushed himself up on his walker and made his slow way down the hall to the room Doris used to call the sewing room. Gary followed, more out of concern for his father's balance than curiosity. Walter stopped in front of a gray 4-drawer filing cabinet that had sat, largely ignored, against the back wall for as long as Gary could remember. What is that? Gary asked. Every deal I ever made on a handshake since I bought this place, Walter said, and pulled open the top drawer. Inside were hundreds of manila folders organized by year, each one holding single-page typed memos, yellowed at the edges, some barely legible where the typewriter ribbon had worn thin decades ago. Gary picked one at random. It was dated June 4, 1981. It read, Denny Coats agreed today to take on responsibility for the north pasture fence line in exchange for me covering his truck repair bill, $340 per Ferris Motors invoice attached. Fence to be completed by August. There was a receipt from Ferris Motors stapled behind it. Gary flipped through more. 1985, 1990, 1994, 1996 the well, 2001 the ice storm roof repair. Each one dated, each one specific, each one describing precisely what was promised, what was exchanged, and what the terms were. Nowhere in decades of folders did the words ownership, half the farm, or inheritance appear once. You've been doing this the whole time? Gary asked, stunned. Every deal I ever made with a handshake instead of a signature, Walter said. I made sure I could prove it later in case memory ever got fuzzy on either end. Didn't figure it'd be Denny's memory that got fuzzy. Figured, if anybody's, it'd be mine getting old. He closed the drawer. Guess it's a good thing I never stopped. Attorney Russell Aldrich was, by regional standards, a sharp litigator, but he had one blind spot that would prove fatal to Denny's suit. He had built his entire theory on the assumption that no records existed. Rural handshake deals, in his experience, left no paper trail. That was the whole reason such cases hinged on testimony, credibility, and the totality of the relationship rather than documents. He prepared Denny for depositions accordingly, coaching him to speak broadly and warmly about Walter's promises, to lean into vague but emotionally resonant phrases. He always said this place would take care of me. He always said I was like a son to him. At his deposition in March, Denny performed exactly as coached. Under Aldrich's gentle questioning, he described decades of unwavering devotion to the farm, sacrifices made, promises given. It was, on its surface, effective. Walter's own attorney, a measured Bowling Green litigator named Priscilla Hume, took notes without much visible reaction. Then Hume began her cross. Mr. Coats, you testified that in 1996 you personally paid for and dug a new well on the property at your own expense, expecting future ownership in return. Is that correct? That's right. Do you recall discussing that arrangement with Mr. Iverson beforehand? We talked about it, sure. Handshake deal like everything else. And what were the terms of that handshake as you recall them? Denny hesitated, sensing a trap he couldn't quite see the shape of. That, I'd put in the well and he'd make it worth my while. Make it worth your while, meaning ownership of the farm. That's how I understood it, yes. Hume nodded slowly and reached into a folder. Mr. Coates, I'm going to read you a document, and I'd like you to tell me if you recognize the arrangement described. She read, dated April 1996, Walter Iverson had agreed to cover the full cost of materials for a new well, invoice attached from a well drilling company to $100, in exchange for Denny handling the labor and future maintenance himself. As a repair, Denny's own tenant house depends on same as the main house. Nothing about ownership, nothing about the farm, a well repair cost split dated and receipted. Do you recognize that agreement, Mr. Coates? Denny stared at the paper. I don't know what that is. It's dated the same month you say the well was dug. Does the amount sound right? $2,100 in materials. Long silence. I think that sounds about right, yeah. So the arrangement, contemporaneously recorded, was a cost split repair on infrastructure serving your own residence, not in exchange for equity in the farm. Is that fair to say? Aldrich objected, but the damage detonated slowly, unstoppably, across the room. Because if one memo was accurate, dated the same month, matching the same dollar figure Denny himself had just confirmed, then the box it came from was not a bluff. It was a ledger, and Denny had just validated it under oath. By the time the case reached trial in June, Hume's strategy had crystallized into something almost merciless in its simplicity. She was not going to argue that Walter Iverson never made encouraging remarks to Denny Coats over 28 years. Of course he had. Any employer who wanted loyal, long-term labor from a good worker said encouraging things. The lawsuit's entire foundation, that vague warmth equaled a binding promise of ownership, depended on there being no contemporaneous record of what these arrangements actually were. Walter's boxes destroyed that foundation folder by folder. On the first day of testimony, Hume walked the jury through 11 separate handshake agreements spanning 1974 to 1999, each one a specific transactional exchange: labor for cash, repairs for rent reduction, overtime for a truck loan, never once framed as a share of ownership. Each one was dated. Several were corroborated by third-party receipts: feed stores, mechanics, a lumber yard in Cave City that had remarkably kept its own carbon copy invoices going back decades. On the second day, Hume called Walter's longtime accountant Ruth Delaney, who testified that Denny's wages, while modest, had in fact been adjusted upward on 4 separate occasions to reflect cost of living increases and additional responsibilities, and that Walter had specifically instructed her each time to make sure Denny knows I see what he's doing and make sure it's fair. The wage records, kept meticulously since the 1980s, showed no gap remotely close to the $650,000 disparity Aldrich's expert had calculated. Aldrich's expert, it emerged under cross-examination, had used a generic statewide average farm labor wage, rather than the documented actual increases Denny received. On the third day, the courtroom finally saw the moment that would end up clipped, screenshotted, and shared throughout 3 counties by nightfall. Hume asked Walter Iverson, seated slow and steady in the witness chair with his cane hooked over the rail, why he had kept every single record for 52 years. Walter answered, unhurried, in the flat, plain-spoken cadence that had not changed since 1973. Because a handshake is a beautiful thing between 2 honest men. But I've buried enough friends and watched enough farms get torn apart by grieving families arguing about what Daddy always said to know that memory bends toward whatever a man needs it to say. I never wrote those folders down because I didn't trust Denny. I wrote them down because I didn't trust time. Time changes what a promise sounded like in everybody's head, including mine. I wanted there to be one place where it couldn't change. He paused. Never once in 52 years and 400 and some folders did I write down that I promised anybody half this farm. If I had, it'd be typed up in that drawer, same as everything else. It isn't there because I never said it, not because I forgot to write it down. The gallery was silent. Denny Coats at the plaintiff's table stared at his own hands. What broke the case completely wasn't a folder at all. It was a letter. Hume, in preparing rebuttal evidence, had subpoenaed records from the Cave City Farmers Cooperative, where Denny had for the past 6 years quietly run a side operation, leasing 18 acres from a different landowner, a retired schoolteacher named Vernell Atchison, to raise his own soybean crop independent of the Iverson farm. Nothing wrong with that on its face. Tenant farmers often worked supplemental ground. But buried in the co-op's paperwork was something else. A signed lease agreement between Denny and Vernell Atchison, dated 6 years earlier, in which Denny, in his own handwriting, on an actual contract, not a handshake, had negotiated a formal 60-40 profit split and a 2-year renewal option. Hume's point when she introduced it was surgical. Mr. Coats, you've testified throughout this case that in rural Caldwell County, handshake deals are simply how business is done, and that no reasonable farmer would think to demand or draft written terms for something as significant as a future ownership stake. Yet 6 years ago, when you yourself struck a deal with Mrs. Atchison for 18 acres of soybeans, you drew up a signed lease with a specific profit split and renewal terms. Why? Denny's attorney objected on relevance grounds. The judge allowed it. Denny answered quietly because it was a business arrangement. I wanted it clear. So you understood 6 years ago how to formalize an arrangement in writing when the stakes mattered to you, Hume said. Yet across 28 years, and what your complaint values at over $500,000 in claimed equity, you never once asked Mr. Iverson to put anything about ownership in writing. No, Denny admitted, I didn't. Because, Hume said, letting the pause sit, you knew, didn't you, Mr. Coats, that if you'd asked him to write down half the farm, he would have told you plainly that was never the deal. Objection, argumentative, sustained. But the jury had already heard it, and more importantly, so had the judge, who would ultimately be ruling on the equitable claims that a jury alone couldn't resolve. The trial's final afternoon belonged to closing arguments, and by then, everyone in that Caldwell County courthouse, the farmers in feed store caps, the women fanning themselves with bulletins, even several of Denny's own distant cousins who'd come to watch, understood which way the wind had turned. Aldrich, to his credit, did not abandon his client. He argued that even flawed or exaggerated testimony didn't erase 28 years of genuine, back-breaking labor, and that some equitable compensation, even if not half the farm, was simply fair given how much Denny Coats had poured into land that wasn't his. It was, in the end, the most honest argument available. Not he deserves half the farm, but he deserves something, and the court shouldn't let one bad legal strategy erase decades of real work. Hume's closing was shorter. She reminded the jury and the judge that Walter Iverson had, by his own uncontested records, paid Denny fairly, adjusted his wages, repeatedly covered emergency repairs to his home without being asked twice, and treated him, by every dated, receipted, corroborated account across half a century, like exactly what he was: a valued, well-compensated, long-term tenant farmer. Not a silent business partner. Mr. Iverson could have destroyed those folders decades ago, Hume said. There was no lawsuit yet, no reason to keep them, except that he believed a promise should mean exactly what it said and nothing more. That habit, that discipline, is the only reason this courtroom knows the truth today instead of two competing, unresolvable memories. The judge, ruling on the equitable claims from the bench 2 weeks later, dismissed the resulting trust and promissory estoppel claims entirely, finding no credible contemporaneous evidence that Walter Iverson ever promised an ownership interest in the property, and substantial documentary evidence affirmatively contradicting that claim. On the narrower wage disparity claim, the judge awarded Denny a modest supplemental sum, $18,400, reflecting a brief period in the late 1970s before Walter's raise records began, calling it a matter of fairness, not of the sweeping equity claimed in the complaint. Denny Coats did not get half the farm. He got $18,000, a public record of his own deposition contradictions, and a co-op lease that had, ironically, helped sink his entire case. Walter Iverson did not celebrate. When Gary asked him, driving home from the courthouse, whether he felt vindicated, the old man just looked out the truck window at fields he'd worked for over half a century. I feel tired, Walter said, and I feel sad. Denny worked hard for me. I don't doubt that for one day. Somebody just convinced him hard work automatically means half of everything, and once a man believes that, it's awful hard to talk him out of it, even with a truck full of paper. Denny Coats left the farm within the month, moving his family to a rented place outside Glasgow. The two men never spoke again, but 3 years later, when Walter Iverson passed away at 82, Gary, going through his father's things one last time, found the filing cabinet still standing in the sewing room, still full 412 folders, and counting. The last one dated barely 2 weeks before the stroke that started everything. A handshake deal with a teenage neighbor boy for $10 to help move hay bales on a Saturday, dated, described, and filed away like it mattered exactly as much as the farm itself. Gary kept the cabinet. He didn't need it for any lawsuit. He kept it because he finally understood what his father had been trying to tell him his whole life. A handshake is only as strong as the memory behind it. And memory, no matter how honest a man believes himself to be, eventually needs help remembering the truth.